Hi viewers, I am Dr. M.A. Faculty, School of Management, Shastra Deemed University. Now we are going to discuss about the fundamental legal aspects of life insurance. The learning objectives of this session is to develop a good understanding of the fundamental principles relating to life insurance contract, understanding legal provisions and flexibilities pertain to policy owner, understanding legal provisions pertain to agents and insurance companies. The last one is understanding the insurance policy documents. So what are all the documents we have to be maintained at the time of taking insurance policy? Okay. The first one is introduction. Okay. The business of life insurance aims to protect the economic value of the life of a person. Though a contract of insurance, the insurer agrees to pay a defined amount of money or provide a definite service if covered event occur during the policy term, provided the policy owner or insured pays a stipulated consideration called the premium. Okay. So already we discussed, whenever we are going to take a insurance policy, it's an agreement between the policyholder and the company. Based on the sum assured, we have to pay some premium. Okay. The life insurance contract was subject to legislation since 1774 with the Life Insurance Act, Gambling Act. It is also called Gambling Act in United Kingdom. Consequently, with number of legislative link legislations like Policies of Assurance Act 1867, Life Insurance Companies Act 1870, Friendly Societies Act 1896, the Assurance Companies Act 1909, Industrial Assurance Act 1923, Insurance Cost Act 1958, and Policyholders Protection Act 1975 were few to quote. Okay. In India, relevant legislation to life insurance contract or Contract Act 1872, Indian Evidence Act 1872, MWP Act 1874, and Transfer of Property Act 1888. So these are all the act or already passed relating to the insurance in India as well as in abroad. Okay. Now we are going to discuss about the characteristics of enforceable contract. Okay. According to the Contract Act 1872, a contract is an agreement enforceable by law, section 2H. So every promise and every set of promises forming the consideration for each other is an agreement. All agreement are not contract, but all contract are agreements. But usually all agreement are not contract, but all contract are agreements. Okay. An agreement may be legal or illegal. As legal agreement not bound by law, if need not follow the rules. Okay. On the other hand, only legally enforceable agreement is contract. So it can never be illegal. It is always in legal. A contract is defined as an agreement between two or more parties to perform or abstain from an act with an intention to create a legal binding relationship. An enforceable contract must have the following requisites: offer and acceptance, consideration, legal capacity to contract, the legality of object. Okay. Then number one is offer and acceptance. Offer and acceptance. An agent merely solicits or invites the prospective insured to make an offer. The applicant for insurance makes the offer and the company accepts or rejects the offer. This accepting procedure is different for property, liability insurance and life insurance. Okay. Then next one is consideration. It refers to the value that each party gives to the other. It's a consideration given in for policies or for other promises. Okay. The insured consideration is payment or a promise to pay the premium and an agreement to abide by the conditions in the policy. The insurer's consideration is the promise to do certain things which are specified in the contract. So, consideration clause summarizes the factors that lead the insurer to issue the policy and represents the insured party of the insurance agreement. It generally is a simple statement that the insured has completed an application and paid a premium in exchange for the company's promise to provide insurance. Okay. This is for consideration. The next one is legal capacity to contract. Okay. The legal capacity is nothing but the competent parties or who are all the eligibility to become this contract business. The parties to the contract must be legally capable of making a contract. They have to be capable person to make this contract. Incompetence is this in this respect suggests that one party could like unfair advantage because of information and asymmetrics of the other. Okay, of the other. Full stop. In connection with the legal capacity for the contract, it is viable if the applicant is a minor, intoxicated or under the influence of other drugs, then mentally incompetent or insane person, and enemy alien. So enemies of other countries. Enemy alien. Okay. This is for legal capacity to contract or competent parties. Then fourth one is legal purpose. Legal purpose or legality of object. To be valid, a contract of insurance must also be for a legal purpose and not contrary to public policy. Right? So all illegal activities which are contrary to the public interest are not enforceable. The purpose of an agreement must be lawful. For example, gambling transactions are illegal and therefore unenforceable at law. Similarly, illegal drug seller cannot take a property insurance against his stock. Okay. As per the Indian Contract Act 1872, insurance is a specialized type of contract where, apart from the above essential of a valid contract, insurance contracts are subject to additional principles. All those discussed essentials of contract have to be fulfilled in the life insurance contract too. In addition to these, insurance contract have some distinguished characteristics. Okay, it is for legal purposes. The next we are going to discuss about the distinguished characteristics of insurance contract. Okay. An insurance policy is a contract and it must therefore conform to the rules of general contract law. Though a contract of insurance, the insurer agrees to make good any loss on the insured property or loss of life that may occur in course of time in consideration for a small premium to be paid by the insured. The business of insurance aims to protect the economic value of assets or economic value of life of a person. Okay. Now we have to discuss the following points. Then attestation. The insurance contract is characterized as one of attestation. Terms and provisions are fixed by one party terms and conditions is fixed by the one party. It means insured must accept the entire contract with all terms and conditions of the insurer, highly specialized and technical without any bargaining. So here, once you enter the contract, you have to abide the rules and regulations of the contract. Okay. Then second one is valued policy. Valued policy. Unlike property insurance, life insurance contract is a valued policy, which means the insurer agrees to pay a stated sum of money irrespective of the actual economic loss, which is opposite to the contract of indemnity applicable to property insurance. The next one is unilateral. So here, unlike commercial contract, which are bilateral in nature, insurance contract are unilateral in nature. Usually, all insurance contract are unilateral nature. It means that only one party, the insurer, gives a legally enforceable promise, and the insured cannot be legally forced to pay the premium. But of course, the insurer is bound to accept them and provide protection to the insured when they pay premium in a timely manner. Then fourth one is conditional. An insurance contract is a conditional contract. The insurer obligation to pay a claim depends upon the conditions which are inserted in the policy, like payment of premiums, furnishing proof of death in case of life insurance, and in the case of property loss, immediate notice of loss to the insurer, etc. Okay. So it is a contract, or contract is a conditional contract. Okay. It is an insurance contract, is a conditional contract. Okay. Then last one is aleatory. Unlike a commutative contract, the commutative contract, insurance contract is a aleatory, but it means that the values exchanged may not be equal, but involve the elements of change or an uncertain event. Okay, this is aleatory. Okay, the last one is personal. Property insurance is a personal contract between the insurer and the insured. Okay, in this, insurer insures the owner of property against loss, but not the property. Okay, insured property is indemnified if there is any loss, and it cannot be assigned to another party without the insurer's consent. But life insurance can be assigned to any one, because the assignment does not alter the risk. Okay. Now we are going to enter the important area, the fundamental legal principles of life insurance. So here, insurance contracts are subject to the following additional principles as per the Indian Contract Act 1872. Okay. So as per the Indian Contract Act 1872, the Insurance Contract Act subject to the following additional principles. Okay. One is utmost good faith. So here we need faith. It should be a good faith. The second one is insurable interest. So basically we must have an interest regarding the insurance. Then indemnity. The next one is subrogation. Then next one is contribution. The last one is proximate cost. So these are all the additional principles. One is utmost good faith, insurable interest, indemnity, subrogation, contribution, then proximate cost. Okay. Now we will explain one by one. Now you take first one, the principles of utmost good faith. Here, insurance contract, either life or non-life, is one of utmost good faith, because all insurance contracts based on the good faith. Okay, the rule of cavest emptor, let the buyer beware, which governs the formation of commercial contract, is not applicable to insurance contract. Both the parties need to have utmost good faith in each other. The concerned contracting parties must really on each other honest. Okay, parties must really on each other honest. The duty of full disclosure of material facts rests on both parties. Material fact refers to every fact or information which has a bearing on the decision with respect to the determination of the severity of risk involved and the amount of premium. Any concealment of material fact may lead to a legislative repercussion in the functioning of the insurance company's normal business. Okay, for example, revealing health condition for standard group, revealing health condition for standard group. Okay, the life insurance companies segregate the lives depending upon the state of health of the people, and they charge low premium for healthy people and high premium for people with ill healthy. Okay, if the person supersedes that fact, the other policy holders in the same group have to share the risk. This leads to adverse selection. Okay, the principle is supported by three important legal doctrines. One is representation through an application, then concealment, the third one is warranty. The first one is representation, the second one is concealment, third one is warranty. Now you see representation. The representation is nothing but details given by the proposer through application. In life insurance, the insured has to mention his profession, income, age, family history, general health, ailments suffered, then medical reports, matters relating to contract and character, any criminal records. So these are all the information they have to be submitted at the time of taking insurance policy. Okay, one is profession, information regarding the profession, information about income, age, family history, health, general health about the insurer, then ailment suffered, medical reports, then matters relating to contact and character, any criminal records. In general, apart from that, in general, they have to support all other documents, all fact regarding the condition, frequency of usage, warranty. So these are the information they have to be submitted at the time of taking policies. Okay, then second one is concealment. It may turn out from the representations furnished by the customer that the details are incomplete or any important information is concealed or is misleading. Okay, the fact which must be disclosed. Number one, the fact which would influence the insurer in accepting or declining a risk or in fixing the premium or terms and conditions of the contract. The second one is the fact must be material on the date on which it should be communicated to the insurer. Third one is facts which show that the particular risk represents a greater exposure that would be expected from its nature or class. The fourth one is external factors. External factors which makes the risk greater than would normally be expected. Example, disease like BP, diabetes, which enhance risk factor. Then next one is previous losses and claims under other policies. Any declinature or special terms imposed or previous proposals by other insurers, the existence of other non-indemnity policies such as life and accident, full facts relating to the description of the subject matter of insurance. Example, in life insurance, age, previous medical history, occupation, smoking, drinking habits, etc. In minor insurance, the type of car, in motor insurance, the type of car, whether it has been specifically adopted, details of regular drivers. Okay. So these are all the points are very, very important at the time of concealment. Okay. The next one is warranty. Okay. In case where such minute details, the statement of facts or promise made by the insured known as warranties or expressly included in the insurance policy with the active consent of both the parties, it is binding on both the parties to adhere to it. Only upon the fulfillment of those conditions will the insurer be bound by the contract. Warranties are collateral to the main purpose of the contract. That is, they are secondary to the main convenience, the main convenience of the contract and form a condition cited by the insurer. Okay. The next one is breach of utmost good faith arises under misrepresentation, non-disclosure. Okay. In misrepresentation, whether it is innocent or fraudulent, it must be substantially false, it must be concerned with the fact which are material to the acceptance or assessment of the risk or material to the benefits obtained by the proposer. The next one is induce the recipient to enter into the contract of insurance if the right to avoid the contract is to be enforceable. The next one is non-disclosure. It arises and gives grounds for avoidance by the second party where a fact like within the knowledge of the first party and is not known to the second party is calculated if disclosed to induce the second party to either not to enter the contract at all or else only to enter it on terms which he consider are better. Okay. The next part is rules of life insurance contract construction. Life and health insurance policies are typically written using standard forms containing much technical language. The applicant does not have any opportunity to negotiate modifications in this policy. This Athenian nature led judicial authorities to adopt special rules of insurance contract construction that favored the policy owner. The three common classes of contract construction rules are doctrine of contra profundum, Second one is doctrine of good faith and fair dealing. Then third one is reasonable expectations doctrine. So these are all the three important construction rules of insurance contract. Okay. Then the other rules are presumption of death and disappearances, insuring agreement, then insurer's liability for delay, improper rejection, or failure to act. So these are all the other rules. Okay. Now we are going to discuss about the legal provisions pertaining to an agent, insurance agent. So life and health insurance companies worldwide rely on agent for product sales and customers advice. An agent is the legally representative of the insurer. The broker is the insured legal representative. This misalignment may occur because the inconvenient that motivate the agent usually differ from those that motivate the principal. This may lead to principal-agent problem. To avoid this problem, an entire body of laws has evolved that attempt to establish clear rules of authority and conduct in connection with this relationship. Okay, the power of the agent. The following are the powers usually the agent has: the actual or express, implied, then apparent or perceived. Okay, in actual or express, the granted to an agent by the principal in specific languages or terms. It may involve wide or generally authority, or it may be limited to a narrow field or even to a specific act. Regarding implied is that associated with certain duties such as the cashier authority to take payment for merchandise at a checkout counter. Third one is apparent or perceived. Is when a third person believes the agent possesses the authority because of circumstances made possible by the principal and upon which the third party is justified in relying. This authority is based on the principles of establishment. The principle will be prohibited, that is established from declining later that no agency existed.